Death and Dementia, welcome. And Jennifer Ramirez, who's the attorney that helped out with Mom and Dad's trust, was nice enough to do a video call with me to answer or explain a little bit about the difference between wills and trusts and things like that. Jennifer, thank you so much for taking the time to do this.
You're
What are
welcome.
the differences there?
So I don't think we can start anything without a little disclaimer, right? Attorneys and their legalese, but just so that we're on the same page, we're
Perfect.
going to do a quick disclaimer here. This podcast, right, is made available for educational purposes only, to give you a general information and general understanding of the law, not to provide specific legal advice. By using this podcast, you understand that there is no attorney-client relationship between you, the listener, and me and my offices, the law offices of Jennifer E. Ramirez, APC. And certainly this podcast should not be used as a substitute for competent legal advice from a licensed professional attorney in your state. Having said that, let's begin. Yeah, so it's a very common question, will and a trust. Let's break it down. And this is here, we're here in the beautiful state of California, where we're known for taxes and complication, right? So that's what we do. Here in California, well, first of all, a will serves really two purposes. One is to name the personal representative or the executor of your estate, and two, the beneficiaries of your estate upon passing. So a will is only in effect once you die. So I say, this person is my executor, these are my beneficiaries. So once I die, the executor will follow that instruction and distribute those assets accordingly.
Okay.
A trust has multiple purposes. First and foremost, it's a living contract. That's why we call it a revocable living trust. It's a contract in life. So one big purpose, and especially for this podcast, is if you set up a trust, you typically name a trustee to manage your assets if you become incapacitated in life. So here's one distinction. Will only effective after you die. A living trust is in effect during your lifetime. So you name the person or persons that will manage your assets under the trust upon your incapacity. Fast forward, upon your passing, then the trustee will also have the same purpose, like in the will, to administer your assets and distribute those assets to the beneficiaries under the trust. So big distinction is a revocable living trust is a document we use in life. It's not only when you die, but while you're living, if you become incapacitated, this document can name the person who will handle your assets. And then what happens, let's say, upon passing? The way we administer these documents is a very big distinction here in California. So let's just say I have a house. Upon my passing, I did not set up a trust ever in my life. So when I die, either I have no estate planning documents or I have a will. In that situation, being that I have a house, and let's just say assets above $185,000, then the executor of my will have to initiate a probate. Probate is a court proceeding where you have to present the will, the court approves the appointment, oversees, the administration of the estate. And this here in California can take about 9 to 12 months, depending on the county and the calendar. Big thing on that are fees. Probate fees are quite high because they're based on the gross estate. So if my house is worth $1 million, even if I have a $500,000 mortgage on it, on $1 million estate, the attorney is entitled to $23,000 in attorney's fees, and the executor is also entitled to $23,000 in attorney's fees.
Oh, wow.
I mean, and you add in court fees, probate fee, I mean, you're almost at $50,000 in fees in administering a will, or if you don't have any estate planning documents at all. Now let's contrast that. Same example, I have my house. I set up a trust in life. My house is in my trust upon my passing. And this is, let's let's assume my children get along, there's no fighting, they're gonna get 50-50. We have none of that drama. My trustee is going to be able to administer my trust in the privacy of an office, pay an attorney hourly, that's not nearly gonna be anywhere close to $23,000, and get those assets to my beneficiaries, let's say in 6 months or less, if everyone is on board. So a living trust, you're avoiding court upon passing. It's a private document. It's also in effect if you are alive and incapacitated. So we're really trying to cover all the bases with a living trust. Depending on your assets and circumstances, you may not need one. That's why it's important to discuss this with an attorney. But I think it'd be fair, a general statement, that if you have real estate or you have assets, it's worth talking to an attorney about it, because it really serves that benefit of avoiding the time and cost of court.
Great, I know you mentioned that we're in California. Does that differ, I guess, per every state's got some different definition or procedure probably?
That's my understanding. I have heard from other practitioners in other states that it's cheaper and quicker to do a probate through a will in some other states than having a trust. So it just depends. But here in California, as a general rule, having a trust will make this a quicker process and is typically less expensive than having a probate administration.
Okay, and I talked about it in prior videos. I went through dealing with my brother's estate and a different attorney because no conflict of interest. And he had no trust, no will, and that was an absolute nightmare to deal with. So I feel what you're talking about there.
It's a hard one to,
yeah.
It's emotionally difficult dealing with someone's passing, and then you're put under this, I mean, I guess this additional burden of now having to navigate, probate and the documents and the court dates and all of that. It's hard. It's hard.
Yeah. With along with that, and I know what we've dealt with too is things in the trust, or I don't know if they're in the trust or separate from the trust, like healthcare power of attorney, release of protected health information, and all those things, because we're now making decisions for mom and dad's medical conditions. Is that part of the trust, or is that something outside and separate?
Right. So the trust, yeah, that would be separate from the trust. So the trust document does touch upon incapacity, right? So if the person who set up the trust becomes incapacitated, the trustee named under this document would have control, be able to manage those assets for the benefit of that person. But we're only limited to trust assets. There are some assets that we don't transfer into a trust. For example, retirement accounts, 401k, IRAs, those typically do not go into a trust. Those stay under the person's individual name. So if that person is incapacitated, it's the general durable power of attorney, or power of attorney as most people refer to. That document gives access to the person named to manage assets that are not in the trust, right? That are outside. So when you do a complete estate plan, if you will, you generally have your trust, you have a financial or legal power of attorney, and then, as you just mentioned, you also have a healthcare or an advanced healthcare directive. So the trust and the power of attorney, financial legal power of attorney, deal with financial and legal assets or matters. The directive or the healthcare power of attorney deals with medical decisions if you can't make those for yourself. And in addition, you can specify certain instructions, right? I know it's everyone's worst nightmare. I hope not, but if if you have an end-stage condition, terminal illness, certain illnesses or conditions that you may have, you can leave specific instructions for your agent on what kind of care you want. So they are separate documents, but they should work together to make sure you cover those bases, that if you become incapacitated, you have someone designated to make healthcare, legal, financial decisions for you. And that they also have access to, financial assets to help pay for this care or to make these decisions for you. So it all works together, so that if this does happen, that you become incapacitated. Because a lot of times we focus more about passing, right? Oh, when I die, it goes, this is where it goes. But unfortunately, as your podcast is dedicated to, I mean, dementia is very common, and this is happening more and more. And so people are living longer, but could be incapacitated a good part of that. And so that's why these documents are very important to plan before this happens to you.
Yeah. Yeah. And fortunately, and with your help and like I said, other attorneys got the documents done beforehand. If one person asked me on a comment or on the phone, what would happen if I hadn't gotten the healthcare power of attorney and all those things, and then mom and dad get dementia, and it gets to the point where I come to you and you say, hey, they've declined too far for me to allow them to sign anything. That happened to somebody who I was talking to. What do they have to do at that point?
They're going to have to explore a conservatorship of the person or the estate. So this would be a court proceeding, where the judge, I mean, the person, for example, if my parents are, incapacitated, they never signed anything, and my sister goes, you do it, then I would have to file a petition in the probate court so that I'm appointed the conservator of their person to make their healthcare decisions and conservator of their estate to make financial decisions for them. But again, now you're talking about court supervision, petition, all of that. I don't handle conservatorships, but it is a more complicated process that could have otherwise been avoided in planning beforehand. So it's not that nothing can be done. Certainly you can do a conservatorship, and the flip side to it, I know it seems onerous, like, oh boy, now for mom and dad, I have to go do this court petition. But you don't want just anyone going to your bank or, managing your legal financial. You want it that if you didn't sign a power of attorney, for example, that there's a court order, there's a legal process for someone to take on your legal financial matters, because whether it's under a power of attorney or a conservatorship, I mean, someone else is going to have very broad powers, right? And making legal financial. And I think that's something you probably on this podcast has gone into. I mean, every small detail that you don't think about, you've had to handle. Big decisions, small decisions. I mean, we don't think about it. It's canceling the utilities, cable, this, that, change. I mean, it's a lot. And so you have to do that. So if you don't have a legal document like a power of attorney signed, we want to make sure that there's a court appointment, not just anyone is doing this. But that is the answer. You would have to go to court.
Okay.
Yeah.
Great. Is there anything else that you would, people dealing with this that you would want to let them know?
I would say for the family members, friends that are taking on this responsibility, I have the utmost respect for you. I mean, the emotional burden you're going through, again, having to take this on, this responsibility apart from your own personal affairs is extraordinary. And I give yourself some grace in that you can't do it all. There's small things, big things, and certainly get the help you need, whether it's talking to someone just for emotional support. Certainly, an attorney can help you with a lot of the legal documents and getting access to the accounts and taking control over these assets that you're managing, if you're that person who's given that responsibility. On the other end, if you are someone that has yet to sign these documents or prepare them, I know it's difficult to think about incapacity, about death, but it's going to be more difficult for your family or friends having to navigate that without any instruction. you
Yeah.
know, or having to go to court. So it's hard, and I don't want to minimize how difficult that conversation is. But that's why it's just really important to work with someone that you really like. You know, I'm not saying me, it could be any attorney, any professional that you trust, that you feel comfortable with. You know, it's really important to have those conversations, and either get your documents prepared so in case this happens, or if you're the one tasked with handling these responsibilities, you're working with someone that can help you and support you.
Perfect. I'm glad you brought that up. Thank you so much. And like I said, the healthcare part, my brother and I have, you've met my brother. Thankfully we get along great. He's one of my best friends. But to make medical decisions for mom and dad is something that I still really can't wrap my head around, that I have to do.
Hmm.
And not only having procedures, but deciding not to have procedures is, yeah,
Wow.
it's a tough one, but we have good doctors now and everything. But thank you so much for taking time out of your day. I know you're busy for this. I'll put your website up on the link, and hopefully we talk soon.
Absolutely. Thank you for having me. And to all those watching this video, you are so lucky that Brian is doing this. This is a service to everyone, just humanity in general, that this is what we're going through in our generation. And this is such a helpful video for all. So thank you for doing this.